We begin at the nation's highest court. CBS News has obtained a copy of a Supreme Court opinion accidentally posted to the court's website Wednesday. As first reported by Bloomberg Law, the justices seem prepared to allow women to have emergency abortions in Idaho. A court spokesperson confirmed to CBS News, quote, the court's publications unit inadvertently and briefly uploaded a document to the court's website. The court's opinions in these cases will be issued in due course. Final opinions, of course, could change before they're officially released. Also on Wednesday, the Supreme Court handed down another win to the Biden administration. In a 6-3 ruling, the justices said the White House and federal agencies can continue telling social media companies to remove misinformation. The case stemmed from a lawsuit led by Missouri and Louisiana, which claimed the administration unconstitutionally blocked conservative points of view about subjects such as COVID-19. The decision will not affect the typical social media user. Here to break this all down for us is CBS News legal contributor Jessica Levinson. She's also a professor at Loyola Law School in Los Angeles. Jessica, good to see you. This is not the first time this has happened, an opinion accidentally coming out or being leaked. Is it different than prior cases, and what does this mean?
It is. I would say before the I was going to disagree with you in the sense that I think this is the first time we've had an opinion be accidentally put up on the website. And now this is, I think people are saying, this is a decision about abortion. Obviously, Dobbs, almost 2 years to the day, was a decision about abortion. We got a draft of that case, but it's very different. In the Dobbs case, that was a case that overturned Roe v. Wade, again, almost exactly 2 years ago. Somebody took that draft and gave it to members of the media. In this case, I think what we're talking about is an IT issue where a file was uploaded to the Supreme Court website, and it frankly shouldn't have been. So yes, two big Supreme Court cases. We get the opinions before the opinions are released, if this opinion actually holds. But I think two very different reasons why. One intentional, I think one accidental.
Okay, so if this opinion does then hold and doesn't change very much, it just sends it back down to lower courts.
That's right. If the opinion holds, then what the Supreme Court is saying is, you know what, it's too soon. We said we would hear this case, but things have changed on both sides. And Justice Barrett's concurrence, if this holds again, says essentially Idaho's position has changed. The Biden administration position has changed. The facts on the ground have changed. And so we think that we're not the proper venue anymore. We agreed to hear the case, but we should, in fact, just send this back down to the Ninth Circuit, let them make a determination based on the new understanding of Idaho's law. And yes, maybe then it will come back to them, but not necessarily. The Supreme Court is saying for now, not it. Go back to the lower court.
Which means nothing has really changed for them. They're still saying, let states deal with this.
Well, actually, I think what they're saying, because this goes back to the lower court, is that the federal law will stay in effect. So it's not going to be up to Idaho to keep their law in effect. Going back to the lower court means that the federal law stands and there is still a temporary pause on Idaho's law.
Okay. Wednesday's social media case as well, I want to talk about. Conservative Justice Amy Coney Barrett said in her majority opinion there was no legal standing for the states and other parties to sue the federal government in this case. That's when they're upset, they're being told to take something down that's online, correct?
That's exactly right. So there were individual plaintiffs and state plaintiffs. And in this case, they both went to court and said, the Biden administration forced us to moderate the content on our platforms. In one case, it was individuals, trade associations. In another case, states. And what the court said with respect to all of those people challenging the Biden administration's actions here was, you don't have enough of an injury. You cannot tie what you claim is the problem here, which is content moderation decisions that you made. You can't tie that to the government action that you're complaining about. And until you can show that relationship, you don't have standing to walk into the courthouse door. So far, the theme of our conversation is don't come into this court. In one case, we shouldn't have agreed to hear this case. In another case, the wrong plaintiffs came.
Jessica Levinson, as always, good to see you. Thanks for the perspective.